California Civil Procedure Handbook rules, selected statutes and cases, and comparative analysis. Chapter 9, Appeals and Writs. A. Appeals. 1. Appealable judgments and orders. California Code of Civil Procedure 2007, Section 904.1, Judgments and orders that may be appealed. A. An appeal, other than in a limited civil case, is to the Court of Appeal. An appeal, other than a limited civil case, may be taken from any of the following. 1. From a judgment, except A. An interlocutory judgment other than, as provided in paragraphs 8, 9, and 11. Capital B, a judgment of contempt that is made final and conclusive by Section 1222, or C, a judgment granting or denying a petition for issuance of a writ of mandamus or prohibition directed to a municipal court or the superior court in a county in which there is no municipal court or the judge or judges thereof, that relates to a matter pending in the municipal or superior court. However, an appellate court may, in its discretion, review a judgment granting or denying a petition for issuance of a writ of mandamus or prohibition, or a judgment or order for the payment of monetary sanctions upon petition for an extraordinary writ. 2. From an order made after a judgment made appealable by paragraph 1. 3. From an order granting a motion to quash service of summons or granting an order to stay the action on the ground of inconvenient forum, or from a written order of dismissal under Section 581D, following an order granting a motion to dismiss the action on the ground of inconvenient forum. 4. From an order granting a new trial or denying a motion for judgment notwithstanding the verdict. 5. From an order discharging or refusing to discharge an attachment or granting a right to attach order. 6. From an order granting or dissolving an injunction or refusing to grant or dissolve an injunction. And 7. From an order appointing a receiver. 8. From an interlocutory judgment, order, or decree hereafter made or entered in an action to redeem real or personal property from a mortgage thereof or a lien thereon, determining the right to redeem and directing an accounting. 9. From an interlocutory judgment in an action for partition, determining the rights and interests of the respective parties and directing partition to be made. 10. From an order made appealable by the provisions of the probate code or family code. 11. From an interlocutory judgment directing payment of monetary sanctions by a party or an attorney for a party in the amount exceeds $5,000. 12. From an order directing payment of monetary sanctions by a party or an attorney for a party if the amount exceeds $5,000. So one is an interlocutory judgment and the other is an order. 13. From an order granting or denying a special motion to strike under sections 425.16. B. Sanction orders or judgments of $5,000 or less against a party or an attorney for a party may be reviewed on appeal by that party after entry of judgment in main action, or at the discretion of the Court of Appeal may be reviewed upon petition for an extraordinary writ. Notes and questions regarding appealable decisions. Generally speaking, the right to appeal is governed by statute. The Code of Civil Procedure Section 904.1, reproduced above, sets forth the statutory authority for appeal from a superior court in an unlimited civil case. Sections 904.1 delineates when an appeal may be taken to the appellate division of a superior court in a limited civil case. 904.5, by reference to section 116.710 through .795, indicates when an appeal may be taken from small claims court. Sections 1294 and 1294.2, specifically appealable orders in arbitration, and a few other statutes contain special appeals provisions. For example, Family Code 2025, CCP 597. However, the statement often repeated by the courts that the right of appeal is wholly statutory. For example, UAP-Columbus JV 326132 versus Nesbitt of 1991, Kinoshita versus Horio in 1986, is misleading. The California courts permit appeals in certain circumstances despite the lack of statutory authority. These non-statutory bases for appeal are discussed below. 2. The one final judgment rule. California supposedly follows the one final judgment rule, the essence of which is that an appeal lies only from a final judgment which terminates the proceeding in the lower court by completely dispensing of the matter in controversy. See Kinoshita v. Horio, 1986, Bank of America National Trust and Savings Association v. the Superior Court, 1942. Essentially, a judgment is final so as to be appealable when no further judicial action by the court is essential to the final determination of the rights of the parties to the action. This is the UAP-Columbus JV again versus Nesbitt, 1991. Quote, "It is not the form of the decree, but the substance and effect of the adjudication which is determinative. As a general test which must be adapted to the particular circumstances of the individual case, it may be said that where no issue is left for future consideration except the fact of compliance or non-compliance with the terms of the first decree, that decree is final." End quote. Lyon v. Goss of 1942. As a general test of whether a trial court's decree is appealable or not, the one final judgment rule is obviously inaccurate. Code of Civil Procedure 904.1 authorizes appeals from several non-final or interlocutory orders, such as orders granting or refusing to grant a preliminary injunction and certain sanction orders. CCP 904.1A, 6, and 8 through 12. Moreover, as discussed below, the California courts have developed significant non-statutory exceptions to the rule. Judge-made exceptions to statutory one final judgment rule. There are at least 2 judicially created exceptions to the one final judgment rule. A, ruling on a collateral matter, and B, judgment final as to one party. A, ruling on collateral matter. Perhaps the most frequently utilized exception is a ruling on a collateral matter, which has been defined by the California Supreme Court as follows. Quote, "When a court renders an interlocutory order collateral to the main issue, dispositive of the rights of the parties in relation to the collateral matter, and directing payment of money or performance of an act, direct appeal may be taken. This constitutes a necessary exception to the one final judgment rule. Such a determination is substantially the same as the final judgment in an independent proceeding. In remarriage of Skelly, 1976. The courts have applied this exception to permit immediate appeal of interlocutory orders in a variety of circumstances, including certain orders for payment of money sanctions. I.J. Weinrot and Son, Inc. v. Jackson of 1985, and orders reducing temporary spousal support in remarriage of Skelly, Supra. Some courts do not always require, but for this exception, to apply that the collateral order direct the payment of money or the performance of an act. See example, Truck Insurance Exchange versus Fireman's Fund Insurance Co. 1992, which is an order disqualifying attorney, is immediately appealable as a collateral matter, and Meehan versus Hops of 1955. But most courts conclude that judicially compelled payment of money or performance of an act was an essential prerequisite. See Conservatorship of Rich, 1996. A Superior Court order refusing to allow substitution of attorneys was not appealable under the collateral matter doctrine. Ponce Brand versus Trustees of California State University and Colleges of 1996, trial court's order denying a motion to appoint counsel was not appealable under the collateral order doctrine because the order did not direct the payment of money or the performance of an act. Samuel versus Steve Doring Services, 1994, after surveying prior Supreme Court decisions, collateral order doctrine held limited to situations where trial court orders either payment of money or performance of some act. B. Judgment final as to one party. When litigation involves multiple parties and a judgment is entered which leaves no issue to be determined as to one party, that party may immediately appeal that judgment even though the litigation is not final as to other parties. Justice versus Atchison, 1977, dismissal of all causes of action pleaded by one or two plaintiffs constitutes appealable judgment even though remaining plaintiff had joined in some of these causes of action. Disapproved, though, on another point was Oka versus Superior Court of 1985, Hydrotech Systems Ltd. versus Oasis Water Park of 1991, an order dismissing fewer than all defendants from an action is a final judgment to them and thus appealable. This exception is to the one final judgment rule apparently is the rationale to numerous holdings that an order denying a motion to certify a class action is appealable. For example, Richmond v. Dart Industries, Inc. of 1981, Dar v. Yellow Cab Co. of 1967, demur sustained as to class action allegations is tantamount to a dismissal of the action as to all members of the class other than the plaintiff. I believe the last note in Section A is for stays pending an appeal. Code of Civil Procedure Section 916A states that the perfecting of an appeal, i.e. the timely filing the notice of appeal, automatically stays enforcement of the trial court's judgment. However, the numerous exceptions contained in CCP Section 917.1 through 917.9 swallow up the general rule. For example, a judgment for monetary damages will not be stayed pending appeal unless an undertaking is given. 917.1a, an undertaking means the furnishing of some type of authorized security, such as a bond by a surety insurer pursuant to CCP 995.310, or depositing money or negotiable instruments into court pursuant to CCP 995.710. The amount of the required security is 1.5 to 2 times the amount of the money judgment. Depending on the type of security furnished, 917.1b, the filing of the notice of appeal does automatically stay enforcement of several common types of judgments under the general rule, including appeals from mandatory injunctions and pursuant to CCP 995.220, judgments against public entities and public officers. So the next section is going to be the time limitation for appeals in the next recording.